We're here this morning to hear oral arguments in the case of this Marcus Martin, first case this morning?
Yes.
State of Ohio versus Marcus Martin. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We're being visually and audibly recorded to be posted online, so please try to remain behind the front podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Good morning, Your Honor. My name is David Dowd, and I am counsel for the appellant Marcus Martin. I would like to reserve 3 minutes for rebuttal this time.
Thank you.
Your Honor, this morning I would like to address two aspects of the briefing. As the court is aware, the main issue raised was ineffectiveness of the trial counsel. There are two aspects I want to raise this morning. The first relates to the open-ended questioning of a detective that allowed in evidence of Marcus Martin's not only record, but prison record. Oh, the front, okay, sorry, I didn't know which one you meant by front.
The front one here, sorry.
Makes you feel any better, I would have stood back there.
Yeah.
It looks like the appropriate one, but this is for the purposes of the camera.
Sure, not a problem at all. Anyway, just to pick up where I left off, so that you address the ineffective two aspects. One of it is that the court or the defense counsel himself opened up through a detective that allowed in evidence not only of Mr. Martin's record, but the fact that he'd gone to prison for having a record, and the second aspect being the admissibility of the text messaging. To begin with, as the court knows, this is one of those unfortunate mob incidents where Mr. Martin's brother had believed somebody had broken into his house. He thought he knew who it was. Phone calls were made. There was a vigilante force that went around to find. Of course, the first person they found was the wrong person, was innocent, and it was really mob mentality. The issue directly for the jury was the fact that the actual shooter, Tristan Belfiore, I think that's how he say his name, was a juvenile, was whether Mr. Martin had encouraged him or directed him to do the shooting. And there were witnesses that came in that heard him say, or said they heard Mr. Martin say, "Shoot that nigga." The defense denied that, found that he wasn't credible. So the issue in this case was whether the urging by Mr. Martin was credible. The problem in this case is that obviously defense counsel, in questioning a detective, ended up asking him, I'm going to back up for a second. The strategy you would think in a case like that would be to separate Mr. Belfiore from Mr. Martin as much as possible, that they weren't acting in concert, that they weren't together. Inexplicably, defense counsel, with the detective, start asking, what's their relationship? And the detective answers, Mr. Belfiore looked up to him as brothers. And then defense counsel's like, so they're like brothers? And the detective himself stopped and was like, well, can I answer this? Because it was obviously hearsay, and the judge said, look, you're not the judge. There's no objection, keep going. Then what comes out was that the detective indicates through defense questioning that they saw each other 2 to 3 times since Mr. Martin got out of prison. The problem with that obviously is twofold. The questioning, which the prosecutor hadn't done, brought out that they saw each other all the time, which again doesn't help the defense, but more importantly, the record came up. Now, it is accurate that what he was in for was not brought out. What the offense was not before the jury. But what is known is that he did time for that. He spent prison, so it's a serious offense which the jury would just conjecture.
Counsel, I have a question for you
Sure.
about that. And please correct me if I'm wrong,
Sure.
Wasn't the detective statement, I guess what I'm saying is, didn't the detective statement actually place your client and the shooter in prison? Or did it just refer to your client? I thought I read somewhere that it made some reference to them both getting out of prison.
Well, my notes and my reading was that once the defendant got out of prison, but even if it was both, it would still be irrelevant, because the problem here is, if you're talking about credibility, and let's say that the evidence was that there's no evidence of Marcus Martin having any record, versus a record which Marcus Martin not only had a criminal past but went to prison for it. In a case like that, would the jury more likely to believe that he ordered the shooting if they know he went to prison for a crime or if they knew nothing about it? So the error in this case is the fact that by pointing out the fact that Mr. Martin had a criminal record he went to prison for, it's more like he is the type of person, the background of what, it wouldn't be inconsistent with who he is that he might have done so. The problem here is the detective kind of blurted it up. I mean, obviously defense counsel didn't say to him, does my client have a record? And the detective kind of blurted it up. But defense counsel did nothing at that point to strike it from the record. It clearly was improper, but he didn't ask that it be stricken. He didn't ask for limiting instruction. He didn't ask for the jury to explain, or excuse me, the judge to explain to the jury, look, ladies and gentlemen, at last you can't consider that for any reason. You must strike it for your mind and let it go. So the jury was free to consider it for any reason that they wanted to at that point in time. So that this basically allowed the, when weighing credibility, it added a little something that shouldn't have been there when the jury was trying to decide if Mr. Martin made the statement ordering Belfour or requesting that Belfour do the shooting.
Can I put a little twist on that?
Sure.
I'm reading that unsolicited response you're
Yes.
discussing, assuming it's correct in the brief. I don't recall exactly, but I believe Tristan said it was 2 or 3 times a week once he and Markus got out of prison.
Well,
I guess what I'm saying is, if the defense is, this kid thought on his own, he's not beholden to what I might or might not be telling him to do, doesn't the fact that he was also in prison actually help the defense?
I'm not sure how that does, because if it comes out that he was also in prison, indicated that the closeness of the relationship, that they might have been pals before. If they get out together, they're hanging out together, they're hanging out 2 or 3 times, and so that in this idea that he's looking up to Martin would make him more susceptible to Martin's demand, Martin's order, and more likely that Martin might say something like that directly to him. So I don't think that helps the defense.
So the finder of fact should leap that they were best friends in prison and in the same prison, or
Well,
isn't that a jump?
I don't think it's that small of a jump. If it brings out that, look, they were together there, and as soon as they got out, they're together too, because it would seem unlikely, that if they didn't know each other, all of a sudden they start hanging out 2 or 3 times, it actually would make it more credible that they were together 2 or 3 times a week if they had been in prison together. The second aspect of the case, which is unique, and I couldn't find a lot on it, was the fact that the detective, one of the problems here were there are these texts, which were very damaging texts, and the texts were written, and for lack of a better term, in slang. And so when you read them, I personally had to, and I deal with this stuff, I had to read them out loud to kind of figure out what they were saying.
They don't give us text interpretation.
They don't give us text interpretation, and that's kind of exactly my point here, is that, and so and there's no question I'm not questioning what the detective said is accurate. I'm taking it on face value. But the detective was a computer recovery specialist. I don't know what that is. I've never seen that in the case before. I'm not sure if that's a science. But he was designated that by the police, which is fine. And he indicated that he would download, to recover the phones, he would download the information into a computer, and then there was a program, a universal extraction device, which would then extract what had been on the cell phone, and I guess would put it out as we have here, some of which is very damaging. The problem with this is that in any case, if there's a program, it's science technology, there was no vetting here. We don't know how accurate this was. Who made it? Did they do accuracy tests? How was it programmed so that it would take what's off the phone into these muddled words? And an example, in my brief, the fourth example is, it was make sure Yo and his PPL, which I'm assuming is people, keep shit under wraps, bro, at fat house. Later they changed it to dat house. The point is, there's a mistake made. So how do we know, especially when we're just talking initials and letters, how do we know that it's accurate? How do we know, as we look at the record now, we don't know how they came up with this. In any aspect, they have accuracy tests, they vet it for accuracy. Again, is it something that the police can use as a tool to try to, sure, for investigative, but does it come into the courtroom? Is this accurate and reliable enough? And using, Daubert and Kubutain, one of the main things is they want to make sure that it's accepted within whatever community that is, scientific community, and whether, then again, whether it's relevant to the case.
So you're saying this is more of a science than technology?
It doesn't matter. I'm saying it doesn't matter if it's technology or science. I'm saying, yeah, it's the same thing. I'm saying in a situation, if you have a program, for instance, I'll give you another example. The coroner often in these cases, and in fact, in the case I have coming up next, will have a situation where they'll recreate the ballistics on which way the bullets and how somebody had to have been standing and where they went. It's not, that has to be proven, that has to be accepted. Just because you have a program, you can program anything to say anything. What you need for admissibility, which should have happened in this case, is they should have requested a 104 hearing, and they should have put on the detective to explain this program.
Would a detective have been qualified?
I was just gonna ask.
Absolutely not. I don't believe so, that's the point.
So who would they have had?
The company that did the program, the person who trained them, because the programmer in these cases would come in, here's what we did, here's how do you test the accuracy for what's being transferred or translated? Is this like Google translation where, you put something in Spanish and translate to English? I mean, how accurate is that?
So if you were admitting x-rays in like another type of a case, you'd want the person who created the x-ray technology to come in and to testify about the x-rays too?
But that's been accepted over 30, 40, 50 years. So that it's clearly not objected to because people understand it, it's been accepted, it's been part of the court for years. So that's why this technology is different. It's new. I don't know any other case. I've never seen this before. I don't know any case that's been accepted before. I don't know where it's been tried to be introduced before.
So if Verizon phone records hypothetically were to be admitted, you'd want somebody from Verizon to come and testify as the accuracy of the transcription of the whatever text that came off of a phone?
Well, here's what normally happens in those cases is they take the photo of the phone on it. In most text cases, they will take the actual, and I forget the term of it, you take the picture of it, and so you have, what is it?
Screenshot.
Screenshot, thank you. You screenshot, so you can see it. It's not taking it from an encryption of some sort or metadata. It's actually, the screenshot is there, you see what it there, it's taken with there, so it's not an issue. What's different here is we don't have that. It had to be recovered, that's the difference.
But in this situation, it's text messages that were deleted, right?
Yes.
But in many other situations in court, we have, forensic people, I don't know what you call them, but with computer science, they actually go in and recover whole, hard drives.
That's correct. And in those cases, almost in every case that I've been involved, the person is on the stand and he explains how this is done. It's gone through, the basis is done, the accuracy is done, it can be challenged, and so that, and people, as this court is aware, bring in other experts to challenge what the first expert said on its accuracy. But there is a history. In all these other cases, there was a first time. And once they're challenged and accepted by the courts, and the accuracy is established, and such as DNA, when DNA first started, there were Daubert hearings on it for a lot of time, and now it's been accepted by the scientific community, and so we don't have that all the time. This is a first impression. This is a first impression of program we know nothing about, and particularly when we're talking about initials and letters.
You're down to a minute and a half.
Oh, I'm sorry, thank you.
Counsel, it's a first I'm so sorry.
Sure.
It's a first impression for you.
Yes.
If we were to come across other cases where something like this has happened and it was accepted, is it because they were all wrong because they didn't have a Daubert, or can we
Well,
deem it
very
accepted?
briefly, if there is, then shame on me because I missed it. But second of all, sure, this court could use that as precedent to kind of establish it. But again, at this trial, at this time, it was incumbent on defense counsel, one, to keep it out, for obvious reasons, but two, to challenge its accuracy. And so that by not objecting at all, the jury heard it as totally accurate, and then we have the relevancy, which I don't have time to address. But the court understands the argument. So anyway, thank you very much for your time.
Thank you.
May it please the court, Elizabeth Lindberg on behalf of appellee of the state of Ohio. The appellant Marcus Martin was charged for his involvement in the killing of the victim Davion Stroop. He was indicted on August 8, 2014 and charged with aggravated murder, aggravated riot, aggravated burglary, 2 counts of murder, 2 counts of kidnapping, and 3 counts of felonious assault. Following a jury trial, he was acquitted on the aggravated murder charge and found guilty on the remaining counts. He was sentenced to a total prison term of life with the possibility of parole after 20 years. He appealed and raised 2 assignments of error, the first being ultimately ineffective assistance of counsel on 2 different bases, and then that second assignment of error being that the trial court erred in admitting text message content when there was no hearsay exception and it did not pass muster under evidence rules 401 and 403. As to the first assignment of error, the appellant claims that his trial counsel was ineffective because he failed to object, move to strike, or request a limiting instruction in response to a witness's unsolicited statement that the appellant had been in prison. Of course, to make a determination on ineffective assistance of counsel, he has to show that counsel was deficient and that the deficiency prejudiced the defendant in that the outcome of the trial would have been different. In this case, the part of the testimony discussed was with Detective James Homoki. It's at transcript page 484. And defense counsel is asking about the relationship between Marcus Martin and Tristan Belfiore. He's saying, the detective is basically saying there's a brothership style with their relationship, and the defense counsel asked, who informed you of that? He said, Tristan. And then further, as he's asking more questions about it, he asks, did they live together? The detective said, no, sir. And then when asking how much time did they spend together, the detective said, I don't recall exactly, but I believe Tristan said it was 2 or 3 times a week once he and Marcus got out of prison. Ultimately, the extent and scope of cross-examination fall within trial strategy, and debatable trial tactics do not establish ineffective assistance of counsel. Moreover, trial counsel's failure to object is within the realm of trial tactics, and that alone is not enough to sustain an ineffective assistance of counsel claim. First, trial counsel was not deficient for asking these questions. He had every reason to discuss with the detective what the relationship was between Marcus Martin and Tristan Belfiore. The state's argument, and that's discussed a little further in the state's rebuttal closing, that the 2 were close, and that Marcus Martin was like a big brother to Tristan Belfiore, in that Belfiore would listen to him when he commanded him to shoot the victim. And defense counsel, of course, would want to counter that argument by alleging that the 2 were not that close. So him asking these questions certainly does not rise to the level of counsel being deficient. Also, he was not prejudiced by this question or what flowed from it. Given the totality of the testimony proving the guilt of Marcus Martin, this one singular statement could not have caused such an impact on the jury as to place into question Martin's ultimate conviction. The other facts leading to that conviction are that Misty Ellis testified that Marcus Martin approached her residence and demanded that Davion Stroop come outside. Monique Hill saw Ellis arguing with men on her porch with a large crowd of people outside. She further testified that Martin and a group of the men entered her home and started fighting with Stroop before pushing him out of the house. Ellis stated that she saw Marcus Martin hit Stroop in the head with a paver stone. Monique Hill from her home saw Martin hit Stroop with a brick. Moreover, being only a short distance from Belfiore prior to the shot, Ellis heard Martin's recognizable voice, and only that singular voice called out to Belfiore to shoot him, shoot that N-word. Anthony Marcano, a co-defendant in this case, went into Ellis's house with the group of men, including Marcus Martin. As they were leaving, Marcano testified that Marcus Martin and Stroop were locked up, but he wanted to say that Martin was dragging Stroop. After Stroop was hit with the brick by Martin, Marcano stated that Stroop had a look of horror and was scared for his life. As Stroop was running away, once Belfiore pulled his weapon and a female was saying not to shoot him, Marcano heard Martin say, "Hell no, fuck that," shoot that N-word. Marcano testified that Belfiore did not shoot Martin before being told to. Based upon all of those facts and all of the testimony elicited at trial, it can't be said that trial counsel was deficient or in that the defendant was prejudiced by the fact that this one singular portion, one statement came out.
It's a pretty important statement, isn't it?
Well, Your Honor, to go to your point, Judge Callahan, that both it was Belfiore who had been in prison and Martin who had been in prison, it could equally be said that Belfiore was in prison and may have had a violent past and had done this on his own and didn't need any encouragement by Marcus Martin. The fact that both were in prison certainly is one that just was elicited. It makes sense also that trial counsel didn't object to the issue or motion to strike the issue or request a limiting instruction because he didn't want the jury to have their attention brought back.
How about a sidebar objection few 30 seconds later or something? Let me just put it this way.
Yes.
Had there been an objection, I'm going to say sidebar so as not to bring attention, what do you think might have happened as to a detective testifying that he'd gone to prison? It's kind of police officer 101, isn't it, that doesn't get in?
Ultimately, it may have been stricken from the record and the jury instructed to disregard.
Or what else might have happened?
I suppose a mistrial could have been declared. However, if defense counsel were to have raised an objection and done a sidebar, raising the objection itself, the jury immediately is brought back to, okay, well, what happened right before this, that there was an objection, that there was an issue, and you're bringing the attention back to, oh, okay, they were both in prison. So defense counsel did have legitimate reasons not to raise the issue because A, it could have been stated that Belfiore himself was just a violent person, potentially, and would have done this on his own, but additionally didn't want to go back and draw their attention to the fact that Marcus Martin had been in prison. As to the second issue, being a failure to request a Daubert hearing on the accuracy and reliability of the text message data extraction procedure, there is no case law to support the argument that a Daubert hearing is appropriate for a computer system that does cellular phone data extraction. Importantly, I think the biggest part of the argument today was that what is to state that disinformation is accurate information that was taken from the phone, hence underlying a need for a Daubert hearing. First, the defendant was never entitled to a Daubert hearing, so to suggest that counsel was deficient for failing to request something he wasn't entitled to, that it's illogical. There are cases cited in the state's brief, State versus Burrell, State versus Sowers, and State versus Brantley, where detectives testified about analyzing a phone, the computer system used, and the content retrieved, including text messages. And this, of course, was never raised as an issue or brought up in that case. As to the accuracy...
Well, counsel, just because it wasn't brought up doesn't mean that the court has ruled on it then.
Correct, Your Honor. The court did not have the issue of a Daubert hearing in front of them at that time. None of the courts did. However, I think based upon the number of cases that can be found where text messages and their content and cell phone extraction was used, I think that itself speaks to the fact that a Daubert hearing is not generally requested on things like that. When Detective Sumter took the stand and was authenticating the records from the Cellbrite program, basically he said he compares it to the phone to ensure that it's the correct information and that nothing happened that would give an incorrect reading. Detective Sumter will look at the call logs and text messages to make sure that the report matches up to them. In this case, Detective Sumter examined a phone that was taken from Martin. He conducted the extraction on the phone in the way he described, and on the extraction report it provided a number associated with the phone, and Sumter determined that the number was associated with Martin. He was able to authenticate all of this based upon the phone that he actually had and the extraction report. One thing that appellant does cite in his brief are cases that are federal cases involving drug courier profiles. Those are much different than what we have in this scenario where a phone is plugged into a computer and the system brings up all of what was on the phone. In those cases, and the case that's cited, U.S. versus Hernandez-Cuartez, states drug courier profile evidence is nothing more than the opinion of those officers conducting an investigation. Here, what is being pulled off of the phone is what was on the phone. It's not opinion testimony, it's just what was present there.
If I may ask a question. I noticed in your brief you said that he would compare it to the phone to ensure that the correct information, that nothing happened that would give an incorrect reading. Attorney Doughton said that screenshots would be used in other cases. Were there screenshots compared to this case as well?
Your Honor, I am not aware of any screenshots being taken. Some of the messages were deleted messages, which obviously a computer program can get to that the detective wouldn't have been able to get to. I don't know that there were screenshots presented in court, but if the detective had the phone and was able to see things that were not deleted on there and compare them to the report, then that itself would be sufficient for authentication purposes. Basically, so for those reasons, defense counsel was not deficient for not requesting a Dauber hearing on these text messages, but also the defendant was not prejudiced. First, we have to assume that defense counsel was deficient, and then you have to assume that the trial court would have denied admission of the text messages, and then find that the outcome of the trial would have been different. And based upon all the testimony discussed above and the facts elicited at trial, everything else points to Marcus Martin commanding Tristan Belfiore to shoot Davion Stroop. As to the second assignment of error, appellant argues that the trial court erred by allowing the contents of text messaging into evidence as they failed to meet an exception to the rules of evidence and or resulted in unfair prejudice because the limited probative value was far outweighed by the danger of misuse by the jury. As to the first issue in this assignment of error, the admission of text messages was error because it was inadmissible hearsay. That is not accurate. First, the admissibility of evidence is a decision of the trial court, and it's within the discretion of the trial court to make that determination. The state, as just mentioned, the state authenticated the text messages and the retrieval system pursuant to Evidence Rule 901 prior to discussing the content of the messages. But most importantly, text messages were not inadmissible hearsay. They, in fact, were an admission by a party opponent, which is not hearsay under Evidence Rule 801D2. Under that rule, it says the statement is offered against a party and is the party's own statement in either an individual or representative capacity. Martin texted someone, I think the name was Squad in the phone, Tristan bodied old boy. Then later, presumably as to Belfiore's location, because again, we don't have someone who can tell us what all these text messages mean. Still stuck in Megan's right by the body, and then later texted, I know lil homie on stuck right now, about to shit on himself when I gave him that call. Presumably the state arguing gave him that call, telling him to shoot the victim in this case. Martin also then texted another person saying, duh, used the N-word and then said DOA, again, presumably meaning that he was deceased. In State versus Townsend, a case from this court, 2015 Ohio 1124, jail calls were admissible as non-hearsay, and the statements of others on those calls gave context to what the defendant in that case was saying. There were also cases cited in the state's brief regarding text messages in that same light. Therefore, because what he was saying was his own statement, and it was offered by the state against him, it was an admission by a party opponent and not an admissible hearsay. So the second issue that's raised in the second assignment of error is that the admission of text messages violated Evidence Rule 401 and Evidence Rule 403, one being concerning relevancy and one about the probative value being outweighed by the resulting prejudice. Again, the trial court has discretion in this matter to make a determination as to evidence and its admissibility. The relevance and probative value of the text messages is evident upon reviewing them.
And you reached the end of your 15 minutes.
Thank you.
So we have 1 minute left.
That's all I need, thank you. I think that the issues are well set out for the court. The only point that I would like to address in a minute is the prosecutor correctly said that the standard here under ineffective is that the result is different. But that means on the Supreme Court whether the result is unreliable. It doesn't mean that you had to prove, like in plain error, that it would have been not guilty. Because clearly there's sufficient evidence. Sufficient evidence having to look at it like most favorable to the state, I would concede there's sufficient evidence. I didn't argue sufficient evidence. The issue here is, had the defense counsel done what should have been done under the professional norms, such as don't ask a question that you don't know the answer to, don't ask open-ended questions to the lead detective on the case because it gives them the opportunity to put in whatever they want. These are professional norms that must be followed. So the issue is, had this not come out, had he done his job, did that render the result unreliable? And the argument is that it did. Thank you very much.
Thank you. Thank you for your presentations today. The court will take the matters under advisement and issue a written decision which will be mailed to both sides as well as posted to our website, Nevada Supreme Court.